What they are clarifying here, which was a particular concern of mine, and they've taken care of it now, is that if your eviction is only for April 1 rent going forward, you don't have to wait. Welcome, everybody. Thank you for joining us today. We have a couple of things to talk about, which may be exciting depending on your circumstances. And then hopefully we'll get to answer some of your questions. I'm sure a lot of you have questions. I'm going to try to answer as many of them as I can in advance. And then we'll get to anything specific you might want to talk about. So I think the big issue of the day, of course, is the AB 2179. If you actually Google AB 2179, it is hilarious because the first thing that comes up is ABC 10 says eviction extension passes assembly. Deadline for tenants now June 30th. And then Daily California says California eviction protection bill sparks opposition from city officials. Fake news. None of this is true. AB 279 is actually not even that exciting, to be honest with you, which is good news for all of us on this webinar. So I wanted to take a little bit of time to talk about what AB 2079 is not. It does not extend any eviction moratorium because there is no more state level, California level eviction moratorium. That was gone already in September 30th. The law that we had, AB 832, was basically an interim law which delayed certain evictions to make time for tenants and landlords to apply for ERAP. But it never actually created any new defenses to eviction, other than the fact that I've applied for ERAP and the landlord's going to get his money, so I shouldn't be evicted, which theoretically makes sense, right? It does not also give any more time to apply for ERAP. This was another thing that a lot of the tenant groups were hoping was going to happen, and ended up not happening at all. So there's no extension on ERAP. Tomorrow is March 31st, and tomorrow is the last day to apply for any sort of ERAP benefits, both for landlords and for tenants. At the end of the day tomorrow, that's it. You cannot apply April 1. And you cannot apply April 1 for the April rent or for any prior rent. So if you don't apply tomorrow, you've lost your chance to apply for ERAP. So to make it clear, there's no extension of the eviction moratorium. There is no more time to apply for ERAP. So what is AB 2179 and why are people writing stories about it? Well, let's talk about what it does do. Number one, in the last webinar, we talked about the fact that starting April 1, the 3-day notice for non-payment of rent that you would use is the exact same one you had before COVID. Now, if AB 2179 passes, and that's another thing I wanted to point out, it is not passed. AB means it starts in the assembly. And so it passed the assembly. That part is true. That does not create a law. It now needs to pass the Senate, and it's made it through a couple of committees in the Senate. So it's going to happen. But as of today, the law is not passed. I expect between today and tomorrow that the Senate will pass it and the governor will sign it by tomorrow. That's my expectation. But as we sit here today, that's not the case. So assuming the law passes, you will not be using the same 3-day notice that we had before COVID. There's a slightly amended one. And the language is really not that big a deal. It's a notice that says basically before October 1, 2021, if before October 1, 2021, you paid your landlord the 25% of the rent you missed between September 1, 20 and September 30th, 21, and you signed all your declarations of COVID financial distress. Or if you've completed an application for ERAP before March 31, you may have protections against evictions. Go visit this website, lawhelpcalifornia.org. Okay, that doesn't change anything. All of that is still true. And it just gives them notice. And if they had those protections, they would have had them. If they don't have them, they still don't have them. Really doesn't change any laws. So what else does it do? But I'm sorry, but just to be clear, if the law passes, you do need to use this 3-day notice. And if you don't use this 3-day notice, your eviction will be bad. So it's very important that you follow that part. That is going to be true for the 3 months of April, May, and June. April 1, 2022 through June 30th, 2022, right? That's when this new 3-day notice will now apply. Next, what else does it do? When we're applying for you, when we are filing the eviction for you after the 3-day notice has already happened, right? There's a new box that you have to check. Remember before, from the evictions that we were doing from October 1 till March 31, if you were working with our office or any other lawyer, you were having to sign a document or verification under penalty of perjury that talks about what the ERAP status of this particular tenant's rent is. And so you had to, in order to actually file the eviction, you had to have been able to say, they got denied from ERAP, here's a copy of the denial. Or I've applied for ERAP as the landlord and it's been 20 days and no one's responded that the tenant has done their part of the ERAP application. Okay, there's now a fourth box that you can check, which basically says that the rent, that there is no ERAP application pending, which is filed prior to April 1, 2022 to cover any part of the rental debt that is demanded in this case. Now, this is vital, right? Because this maintains the law as it really is and clarifies it in a way that is positive for landlords. Why? Let's say your tenant didn't pay the rent for February and March 2022, right? And you maybe applied for the ERAP, but you never got around to filing your eviction. Now it's past April, and now you want to file your eviction for the February and March rent. Let's say you've given your notices. Fine. For that rent, if you are doing an April eviction for February and March rent, you still have to follow the rules that were in place for that period. You still have to wait your 20 days. And if the 20 days has not passed, there's an application that's still pending, we will not be able to file that eviction for you because you have the application still pending. And there are applications still pending. Technically speaking, there are applications that haven't even been filed yet because they're going to be filed today and tomorrow. So one of the purposes of this statute was to clarify to the court and the clerks that there may still be, and there will be, applications pending for pre-March rent. And for those applications, we still want to delay evictions. That's fine. We knew that was going to be the case even before AB 2179. But what they are clarifying here, which was a particular concern of mine, and they've taken care of it now, is that if your eviction is only for April 1 rent going forward, you don't have to wait. You don't have to wait 20 days. You don't have to apply for anything. You don't have to do anything. All you have to do is mark the box that says there is no application filed prior to April 1 for government rental assistance to cover any part of this rental debt, which is demanded in this case. And as long as you're going for April rent going forward, all of that would be true. Number one, there couldn't even possibly be an application filed before April 1 for April rent because it wasn't due yet. Number two, they're not paying for April rent, so it doesn't matter. No one has an application for April rent, right? So as long as you're only going for April rent going forward, you will be able to check this box. We will not have to wait, and things will be basically equivalent to the way they were before COVID, other than the fact that you have had to use this special 3-day notice, which we just talked about a minute ago. All right. So to me, that's a positive update and a positive clarification. Okay. Another positive thing that it does, at least with regard to the people who are in the county of LA, and I want to clarify, this doesn't necessarily change anything with the city of LA. I will review and explain in a second why, but it does with the county. Now, remember on our last episode, what happened was we were talking about the county moratorium. And we were talking about the fact that the county essentially admitted that they were preempted by state law. The state law they're talking about is AB 832, the last eviction state law. They were preempted, which means prohibited, from changing their moratorium for the period of September 30th, 2021 to March 31st, 2022, because the law specifically stated any changes that were made after August of 2020 do not apply until after March 31. So they said, okay, fine. We're stuck with that because the changes they needed to make were made after August of 2020. But that preemption only applies till March 31st. So come April 1, we are going to reinstitute the COVID defense to a non-payment of rent eviction. Well, comes now AB 2179 and says, no, we're not going to have that only go till March 31. We are going to extend that preemption date through June 30th. Okay, so that basically means that whatever the county did is now not going to apply. What did they do? Remember, they said from April 1 till May 31, we're going to give back a COVID defense to a non-payment of rent eviction for everybody. And then from June 1 till December 31, we're going to limit the COVID defense to people who make less than 80% of the average median income. Well, when AB 2179 becomes the law, that first period, that April 1 to May 31, will become illegal. And there's nothing they could do about it because they admitted that it was this exact same law that preempted them from doing anything before April 1. All they did was they changed the April 1 date to July 1. So now any changes that they made with regard to this particular issue, the non-payment of rent eviction issue, cannot apply until July 1. That's just a simple fact of the law. That means that no one who's making above 80% of the AMI is going to get their county COVID defense to a non-payment of rent eviction back. And I think that's good news. Right now, come July 1, again, whatever the county did do is going to apply. We're going to review some of the things in the county because I think the actual text of the resolution clarifies it. Some of the things that we talked about, which were unclear last time. And certain things that they extended, like, for example, no fault evictions, that will continue to apply, notwithstanding this law and through the entire thing and for everybody. But again, to review what we just said, what we discussed last time for the period of April 1 to May 31 of tenants getting back a COVID defense, that will not apply once AB 2179 comes into effect. Okay. Another thing that 2179 did, which is not so great, is it extended the repayment periods. So before, the law stated that if a local city or county moratorium gave renters a repayment period that was after May 1, 2022, that's not applicable. You can't go beyond May 1 as the beginning of the repayment period. Well, they took that date and pushed it out to August 1. So they get an extra 3 months. On the end period, it's the same thing. The old statute said, if you have a repayment period that ends after May 31, 2023, that doesn't apply. The repayment period must end on May 31, 2023. They extended that as well to August 31, 2023. So those are all the major changes that happened in AB 2179. That's pretty much it. So all in all, I don't see a lot of bad things. There's no eviction moratorium that is renewed or extended. In fact, for the County of LA people, kind of limited the eviction moratorium. So the things that you're reading in the news and the things that people are, losing their minds about on TikTok, unfortunately, is as a result of people not reading this closely enough and understanding really what it says and really what the purpose is. So that's 2179. In terms of the County of LA moratorium, just a highlight and quick review of some of the things we talked about. Number one, for the folks who that matters, remember that the commercial moratorium is dead everywhere in California. There's no more commercial moratorium whatsoever on any evictions. County of LA, City of LA, I don't care what the moratorium says, there's no more. It doesn't exist. So keep that in mind. If you have commercial tenants that you need to evict, we're happy to do that for you, and there are no more protections. So that's number one. Number two, we talked about just before that the phase one, part A, what I called last time, of the April 1 to May 31, that's of giving back this COVID defense, that's not going to happen anymore. But on July 1, what is still going to be the case is that people who make less than 80% of the average median income are going to have a COVID defense to eviction. That basically means that if they come and they can prove that they have a lack of income due to a COVID-related circumstance, they may have a defense to an eviction based on non-payment of rent. Remember, what we talked about last time was also that the county moratorium purported to give these tenants the right to self-certify both their COVID status and their income. And that is still in our mind and in the mind of the United States Supreme Court, so I feel like we're in good company, completely illegal. You cannot be a judge in your own case. That's what the United States Supreme Court ruled when they took up the identical issue for a substantially identical statute in New York. That ruling applies nationwide because that's what happens when the United States Supreme Court rules. The fact that the county is purporting to give people the right to self-certify is simply them saying, yeah, well, we don't care what the Supreme Court does. We're just going to do this until someone stops us. And someone stopping us is exactly what sees the owners that represent the landlords are trying to do, and we'll talk about that in a second. Even a lot of the judges in LA County are also realizing that, self-certification nowadays, when COVID is essentially not really an emergency anymore, really doesn't fly, and they are scheduling hearings for tenants to have to come and show that they have a COVID-related circumstance, and in the case of someone who has to show their income, to prove their income. Although that part, obviously, there's not hearings on yet because it's not July 1 yet. My suspicion, though, is that the courts and the judges will continue to hold these hearings, and for someone who's making less than 80% of the AMI and is claiming the COVID defense, they will require them to come and bring some proof. So that's why we file these types of evictions anyway, unless we know for a fact that those defenses are true. Okay. In terms of no-fault residential evictions, unfortunately, that is still prohibited across the board through the end of the year, December 31, 2022, at least in LA County. All right, now, technically speaking, the resolution that the LA County Board passed doesn't really say much about what happens in 2023. That's really just part of what they planned to put in for that time. They haven't actually passed that part of the law. But if they do, what we're expecting is that it'll just be a continuation of the COVID defense for the less than 80% of AMI people from January 1, 2023 till June 30th, 2023. But the rest of the restrictions should be out. Now, what we were just talking about is the fact that there are a couple of lawsuits going out, that have been filed, one against the city of LA and now recently one against the county of LA, challenging their eviction moratorium. So where are we with those two lawsuits? The first one is the original one. It's the AGLA versus City of Los Angeles. AGLA is the Apartment Association of Greater Los Angeles. They filed this back in June of 2020. It was probably a bit premature, but they didn't have a choice, so I don't fault them. They filed this in federal court, challenging the City of LA's moratorium, and they lost on the trial court district level, took it up to the Ninth Circuit. Of course, they lost there. And now it is with the Supreme Court of the United States. For those of you who are not familiar with the procedure, when you appeal to the Supreme Court of the United States, the Supreme Court is not required to take your case. They can choose whether or not to hear cases, and the Supreme Court takes a very, very small number of cases that get up to that level of application. The process by which you request the Supreme Court to hear your case, okay, is called to seek a writ of certiorari. And right now, that's the briefs that they are filing to convince the court to either take it or not take it. Usually what happens is they apply for the writ, and the defendants, the people who are, or I should say, the respondents, the people who don't want it to be heard by the Supreme Court, generally kind of keep quiet. They don't want to raise a big fuss about it. So a lot of the times they don't respond. Sometimes the Supreme Court will say, we want a response from the respondents. And then they're required to create a response. When that happens, it's generally a sign, though nothing definitive, that the Supreme Court is interested in the case and might want to hear it, because otherwise, why request a response? In this case, they did request a response. So if the cert is granted and the court hears it, it'll probably not happen until definitely next session, best case scenario. But if they do hear it, if they do take it up, I should say, and they do hear it, I think given the breakdown of the justices who are currently on the court, there's a good chance, at least, that they'll overturn it. Now, it may become a moot issue by then, depending on what the City of LA does. But they're essentially, the City of LA is, fighting this tooth and nail, which suggests that they want to keep the moratorium going as long as possible. Every month they do have elections, not an election, a vote on the city council about whether or not to continue the moratorium. Pretty much every month they've been doing it. It hasn't been unanimous lately, but they are getting a decent majority of the council to keep with this moratorium going. This is, by the way, at the same time as for other COVID restrictions, they are releasing them. So the city council, the LA City Council, just voted, or at least they're in the process of voting, to get rid of the vaccine mandate, the law that made it mandatory for people to show their vaccine cards or show that they've been vaccinated before going into certain indoor locations, right? Well, they're taking away that mandate now. Well, why are you taking away the mandate? I thought we had a big COVID emergency. No, clearly we don't. That's why you don't need the mandate anymore. But if you don't need the mandate and we don't have this huge emergency, why are you keeping the emergency on and maintaining this eviction moratorium? Frankly, again, this is just me spouting my opinion, but the fact is, because they like the eviction moratorium, they'll use any excuse to keep it on, even if there is absolutely no science, data, or evidence to support it, because it's obviously very popular with their constituents. Who wants to be the council members that released an eviction moratorium of their own free will by voting for it, right? I think they just simply don't want to. It's politically expedient, and it gives them a certain amount of power to keep this moratorium going. It's infuriating, but it is the reality. So I'm hoping that by the time the Supreme Court hears that it's moot, but if not, I think we got a decent chance if they do pick it up. Now, what's the other litigation? The AOAA, the apartment, I can't remember what that stands for, but it's basically another apartment owners association. That's what it stands for. They sued the county of Los Angeles. Now, remember, the city and the county are two different branches of the, not branches, two different governmental institutions. They are not the same. And the lawsuit that was filed against the county just recently is specifically with regard to this extension of the moratorium that we were just talking about. There is a preliminary injunction hearing set for April 6th. The good news was what happened was when they filed the lawsuit, it was immediately deemed a complex case. That's not complex meaning it's complicated. It's a term of art. It means something when it and creates a whole procedural path that a case needs to file when it's deemed, quote, complex. One of the things that happens in the procedure is that the case is immediately stayed. That means paused, pending a status conference hearing with the judge. Here, what happened was the plaintiffs went in and asked the judge for permission to lift the stay solely with respect to filing a motion for the preliminary injunction preventing the county from enforcing their moratorium pending a hearing on, really pending the resolution of the case. Thankfully, the judge did give them permission to file the motion. They did file the motion. I read it. I think it's excellent. It raises a lot of very salient, good legal points, and it's got great data to back it up. My favorite piece of evidence is the testimony from the county health director herself, where she testifies at a county board hearing that we're not going to have any more shutdowns, not planned and not needed. So when the person who works for the county herself is telling the people who vote for this, hey, we're in a different place now than we were during the original COVID and during the Delta, we really don't have the same situation anymore. And they're hearing this evidence from their own employee, who is the person theoretically in the county who knows the most about the status of COVID and the numbers, and they're still passing a resolution. You can see it's draconian, it's political expedience, it's not constitutional. And they make that point really, really well. So we'll see on April 6th what happens, whether the judge will grant the preliminary injunction, and we'll update you accordingly. So we're going to get to everyone's questions in a second. So if everyone has any questions, please go ahead and continue to put them in the chat, and we'll take them in order. We just wanted to veer off just for a second and tell everyone, if you don't know, there is a new addition that happened to the requirement for residential leases in the state. There's a new mold addendum that needs to be included in residential leases. If you don't have a copy of it, give us a call. We can help you out. It's like a 4-page thing. It looks a lot like the lead addendum, but a little shorter. By the way, though, one of the things that we do at our office is that we do help you prepare customized leases to your specific situations, your specific portfolios, and something that is specific to the way that you may want to do business. A car form is great, but it's not necessarily it doesn't fit for every single kind of use. So if you're interested in getting a customized lease, we'd be happy to help you with that and work with you on that. And we do those on a flat fee. So give us a call, and we'd love to help you with that. Also, just in case anybody doesn't know, at our firm, DSLG, we do a lot more than just evictions or just leases. We are a full service real estate, construction, and landlord tenant firm. We do the evictions, but we also handle matters that are virtually anything having to do with real estate, both on the transactional and the litigation side. So habitability claims, mold claims, bed bugs. If you're a property owner, or if you are a property owner, if you represent a property owner having a problem with the tenants in the neighboring property, or there is a property line dispute, or the neighboring property has a sewer line that runs through under yours and it ruptured, and now there's a whole big problems. Besides what insurance might cover for you, we do help in all of those different situations. If you've hired a contractor or an engineer who has ruined your building or isn't performing on time and you need to go after him, we do that. If there is a contractor engineer who's coming after you because you didn't pay him because he did something bad and you need to be defended on that case, we do that. If you're buying a building or selling a building, purchase agreements, loan docs, creations of LLCs or to cancel an LLC because you're selling the building. We handle all these variety of issues. So please feel free to give us a call or an email. We'd be happy to help with anything you need. So I wanted to get to a few of the questions. So what is the amount that is 80% of the AMI? So that all depends on how many people are living in the unit. We'll see if we can look up the 2022 numbers. Mostly what's coming up is the 2021 numbers. So in 2021, the area median income, it looked like it's like 56,000 for one person. These are not the full numbers though. So what we'll do is we're going to try and find that, and we'll post that or send it out to everybody. But it's basically in the 60 to 70 range for one person, and then as the household size goes up, it goes all the way into the the low hundreds. So the AMI is quite high, in fact, and so it's very possible that you'll have people making less than 80% of that. All right. Another question is, could cities or counties enact local eviction protections starting with the April rent, or would AB 2179 prohibit their ability to do that? Yes, it would prohibit their ability to do that if they are new moratoria, right? Basically, other than, say, San Francisco and County and City of LA, none of the littler cities, smaller cities, are reenacting any COVID moratoria. They're pretty much just relying on what's going on with the state. So if one of the counties or the cities tried to change an old moratoria or enact a new one, as long as AB 2179 passes, they would not be able to do that until after July 1st. Next, if a commercial tenant has applied for federal funds but hasn't received the funds, does that change the ability to evict? No, it does not. So basically, we talked about it last time, that there's a state law that talks about the fact that you really cannot have a local restriction on commercial evictions, commercial leasing terms, the length of a commercial lease, nothing. Those laws were suspended for a little while during COVID, but that suspension expired on September 30th of 2021. So those laws went back into effect, rendering any local commercial moratorium unlawful. So, and I've never seen a commercial moratorium with regard to a commercial tenant getting a break just because he's applied for federal funds. As far as I know, nothing like that exists. So next question is, with the pandemic rules that have been in place, we operated with the understanding that a landlord couldn't send a past resident's past due balance to collections. Does the Assembly bill impact the landlord's ability to send past due balances to collections? What can we do or not do as it pertains to filing collections cases? So this is a very good question. Thank you, Steve. And I want to clarify this. When you say sending to collections, if what we're talking about is simply trying to collect the money that they owe you, not evict the tenant, but just simply trying to collect the money, there are no restrictions on that. Since November of 2021, you can file your claims in small claims for the rent due through September 30th, 2021. You can file in a regular civil court for any of the rent that they owe you. There's pretty much no restrictions whatsoever. The only thing you have to do is for the up till March rent, you do have to sign something that says you applied for ERAP and that you've tried to get the money from ERAP. But that's it. And that's only if you're doing the small claims. If you're doing the regular civil, you just file your claim like a regular breach of contract action. There are pretty much not a lot of restrictions there. 2179 doesn't really change that at all. So you can definitely send to collections. Whether or not the collections people will be successful, that I really can't say. but you can definitely send them to collections. No issues there. So for RSO properties, do we continue to serve 3-day notices? So I assume we're talking about Los Angeles RSO properties. Again, there are the city of Los Angeles takes the position that their moratorium is still in place, and it provides a blanket COVID defense to any non-payment of rent eviction, as long as someone is saying that they have a COVID-related circumstance preventing them from paying the rent or even paying the rent in full. Again, as we discussed, we believe the self-certification portions of that moratorium to be unlawful. On top of which, it doesn't say you can't serve people 3-day notices. It doesn't say you can't even evict people for non-payment of rent. What it says is that you can't evict people or harass them if you know they have a COVID-related circumstance. And how would you know that? Especially if, for example, they had an opportunity to apply for ERAP and never did. That's probably a good indication of the fact that they don't have a COVID-related circumstance, because they chose not to click some buttons to say under penalty of perjury that they have the related COVID-related circumstance. Because otherwise, why would you turn down free money from the state? Right? Doesn't make any sense. The natural logical conclusion of that is that they don't have a COVID-related circumstance, which would provide them a defense to a non-payment of rent eviction. Therefore, fully within your right to serve them a 3-day notice and to proceed with an eviction. If they come in and afterwards show that they have the defense, okay, that's fine. That's their right to come and try and provide their defense, like any defense to an eviction, like a habitability defense or a discrimination or retaliation defense. But that's their job to come and defend themselves. We're not here to make their case for them unless we have actual knowledge that they really do have a COVID-related circumstance. And I'll tell you that, at least in our experience, there really aren't many people who have a COVID-related circumstance anymore. Because before, in 2020, you really might have one. Your job shut down. The restaurant was closed. If you were a waiter, that was your job. Yeah, you weren't making money. That was true. And when the schools were closed and you had to go to your job and you didn't have a babysitter and you didn't know where to put your kid, right? Yeah, that was a COVID-related circumstance where you had to stay home and therefore not make money. But everything is open now. Jobs are aplenty. One of the things that was raised in the AOAA lawsuit against the county is that the unemployment rate in LA County went down to the 6s, right? And it was high 4s before COVID. So it's almost back to pre-COVID numbers, whereas it was in the 15 or 18, something like that, during the worst of the COVID. So the fact of the matter is, for almost everybody, if you want a job, you can get one. If you want a place to have your kid go to school or for daycare, places are open, right? And to a large degree, because of the mass resignation and the labor shortage, wages are going up. Maybe not as much as everyone would like them to, but they are going up. So the whole notion of an existing COVID-related circumstance in March or April of 2022 is just difficult to believe. Could be true, but it's difficult to believe and requires some evidence. So yes, go ahead and serve your 3-day notices. Next, can the tenant still declare a COVID hardship without having applied to the rental assistance program? They can certainly try, yes. But if they haven't applied for the ERAP for the pre-March rent, it really begs the question of, if you have a COVID-related circumstance for not paying, why would you not then go and seek the rent from the state that's giving you free money and helping you to avoid the eviction? So yes, theoretically speaking, a tenant could say that and could just say they didn't understand or didn't know, et cetera, et cetera. But again, it's a little difficult to believe, given the fact that if you're already sitting in front of a judge, it means they got the notice with all the information in it. It's been plastered all over the media and the internet, and social media, and everywhere. So for someone to say, I didn't know that there was free money out there, it's just simply not true. It's right there in the notice. Next, can we evict a resident if they refuse to apply for ERAP? Yes. You can't evict them for that reason, but if they didn't apply for ERAP and you're going after them for the March or before that rent, that's actually kind of a necessity that they didn't comply with the ERAP. And remember, but that means you had to have applied. So remember, the pre-March, if you're going on an eviction, whether it's in April, May, or June, doesn't matter, but the rent that you are demanding is for March or before that, you still have to have showed that you applied for ERAP, and it's been 20 days since the later of the day you applied and the day of your 3-day notice, and you have not gotten an indication from the tenant or the state that the tenant did his part of the ERAP application. If those things are true, only then can you proceed to the eviction, right? And again, we're only talking about the rent through March 2022. If they did apply, you wouldn't be able to do the eviction. So the answer to your question is not only can you evict, but you can only evict if they failed to apply. Okay. So when will we be able to send to collections for balances after 9/30? Right now. You can send to collections right now, right? And try and get the money. They can try and claim that they have the right to pay over time, et cetera, et cetera, et cetera. But you can try to send them to collections now. There's nothing necessarily preventing you from doing that. Where can we find the new 3-day notice verbiage? I can put it right here. All right. The language for the 3-day notice is now in the chat. So that's what needs to be in your 3-day notices. We also have our information up here on the chat now. So if you have any questions, there's my mobile number, direct number, email, check out our website. So now it's just open Q&A. Does anybody else have any questions? Doesn't have to be about what we were talking about. It can be really any landlord tenant legal issue. Please feel free. Anybody? Oh, okay, new one. If they've applied for COVID relief and have given you a case number, do you have to wait to evict until they are denied? Yes, basically that's the way it works. If you have a pending application and you are trying to go for an eviction, which is March rent or before, yes, you have to wait until that process works itself out before you are able to file the eviction. So if they're denied, you file the eviction. If you get paid, then you get paid. But you also might only get paid a part of it. And so if you only get paid a part of it, you kind of have to start the process again. Give them a new 3-day notice. In this particular case, you wouldn't necessarily be able to reapply. That's where the law kind of makes it a little difficult if you're in that specific circumstance, right? And so at that point, I think you could probably say something along the lines of, well, I only got this amount of money from the state. This amount of money is still pending. You do your 3-day notice, and then you file it as if it was denied, because essentially, if you can't apply, it is by definition denied. So our good friend Buddy says, I thought any old balances were to be paid over a 12-month period once the emergency declaration was lifted. Yeah, it does kind of say that in the county ordinance, but again, it doesn't prevent you from sending them to collections to try and see if you can at least try to collect some of the money, right? If they want to come and say their defense, let them come and say their defense. So if a tenant applied for rent relief and was funded, but didn't reapply for the additional rent relief after the funds are applied, can eviction be filed? Yeah, probably. This was a much easier question before March 31st, right? But we run into this issue of what happens after April 1. No one can apply, right? And there's no particular indication of what happens to a person who's already applied and needs to just extend their application. We really don't know if they're going to be letting people do that. It's not clear. If if they will let people extend and they have some room left in the 18 months and their application's already pending, then again, you could have a situation where it's just continuing to be pending. But if they basically say, no, the system is shut down 331, whatever you got, whatever you've applied for, that's what you're getting, and we're not letting even any extensions, then technically speaking, yeah, you're going to have a situation where you have pre-March rent and no application to file and no ability to file, and the tenant not paying. So you will have to go in on an eviction and essentially explain that to the judge when we get to that point, right? But there's no box for that specific situation right now, at least. Okay. Anybody else? Anybody else? Any questions? Okay, here we go. Maurice, if you have a tenant who refuses to participate in the program, has been paying rent on time for the last 4 to 6 months, but still owes back rent, do you serve them with any other notices to start the eviction? So if you've taken, this is the order of things, and this applies COVID notwithstanding. If you have someone who owes you rent from, let's say, like June 2021, right? They didn't pay from June of 2021 till September of 2021. And let's just say in this particular case, they didn't pay their 25% because it's easier to make that example. But then from July of 2021, they've been paying you in full, right? Been a good tenant. Other than that, you've been taking the checks. They still owe you these 3 months, which are within the year, right? But they still owe you this money. What do you do with that? If you've taken money since the time that you've given them a prior 3-day notice, your old 3-day notice is dead. It is null and void, of no use. So you would need to give them a new notice that covers a period that they didn't pay the rent for, right? What kind of notice depends on what kind of period they didn't pay the rent for. In this particular, in my example, you'd have to give them the 15-day notice that applied in the June to September time. If they didn't pay from October to March, you'd have to give them the 3-day notice. And it's going to be stupid, but it's with the ERAP application information. And if they didn't apply, you're giving them a notice in April that is essentially giving them bad information. But that's what the state requires you to do, right? I don't think they fully thought about that particular situation. In fact, the fact that they didn't think about this situation even before AB 2179 came out is evidenced by the fact that they had to do AB 2179 to clarify certain things, but they didn't clarify everything. So again, if we have any questions that are really specific like that, a lot of the time it requires an analysis that is specific to your circumstance. Give us a call, send us an email, or send me a text on my mobile. We'd be happy to talk it through with you.
Niv, I'll add there, Maurice added to his question, would you apply any of the rent? Would you apply any of the rent that they paid towards the back rent before applying it to the current rent?
No, you have to apply COVID rent to the month in which it was given. You are not allowed to take COVID rent and apply it to the earliest rent and then basically say, oh, well, you started paying in October to December, but you didn't pay June to September. I'm going to take your October to December, put it to June to September. Now what you really owe me is October to December. That doesn't work. You need to apply in the month that it was given or prospectively, right? So if they owe you $2,500, or sorry, if they pay $2,500 rent, and let's say they haven't paid for 10 months before June, but in June they cut you a check for $5,000, that is not June and May rent. That is June and July rent, right? So that's very important because a lot of landlords get mixed up on that issue and they start giving out 3-day notices or 15-day notices that are really wrong because the application of the rent was incorrect. Okay, Some tenants insist they continue to pay the 25% of rent because they're still affected by COVID. Can an eviction be filed? Yes. That whole 25% of rent business was over September 30th, 2021. Paying 25% of the rent doesn't protect you from eviction at all after September 30th. That rule doesn't exist anymore. What if the tenant moved out? You get an ERAS check that included future rents, but tenant moved out. Do we cut them a check for the remaining funds? I suppose that's more of an ethical question than a legal question. I can tell you that landlords who call ERAP saying, hey, do you want this money back, are being told, no, you keep it. I can't give you a specific situation, specific names or anything, but the people who have worked at ERAP have said some crazy, have made some crazy admissions to people over the phone. For example, if you have an application that's been pending for like 7 months, that application is probably denied, but they keep it open and pending so that you can't evict the person. We've also seen approvals for $0. Well, you can't say the person got denied. You don't have a denial letter. They just got approved for $0. Now, we don't buy into that. We take an approval for $0. We say, here's a denial. And we file the eviction anyway. We keep going until someone tells us to stop. Right? But they're playing all sorts of games at ERAP. Also, remember the political issues here. The government wants to be able to say, we sent out all this money and we helped all of these people. And they need to be honest about how much money they sent out. Well, if you start sending money back, they have to report a lower number they gave out. And then they have to figure out what to do with the extra money. In government, you can't just take money that you didn't spend and then go spend it on something else, like in a family or a business. It's just lost. They have to give the money back to the federal government if that's where they got it. They don't want to do that. They'd rather keep the money here. So they'll just, generally speaking, they'll probably let you keep it. You can make your own decision about what you want to do that. Call them, don't call them. You know, generally speaking, that's kind of something you can decide on your own. If the tenant applied and the application states in review, and you have knowledge that the tenant has been working, hasn't paid the rent anyway, and he's moving out tomorrow, what action can you take? First of all, find their forwarding address. Figure out where they're moving to so that if you have to sue them, you can serve them. That's number one. I don't know if they'll provide that to you, but if there's some way of finding out that information, get that address. That's number one. Number two, if they're already moving out, there's no point in starting an eviction. So your only real option is to either file the lawsuit now and serve them while you have them in front of you. Wait to see how much the ERAP gives you and then sue them for the rest later. And those are pretty much the options. I wouldn't start an eviction if the guy's already moving because it's just a waste of your time. Just to confirm, we will not be able to evict if a resident shows as non-responsive until we get a denial from ERAP. Not exactly. You're not going to necessarily get, sometimes they will give you a denial, sometimes they'll just show as non-responsive. You get a denial, what that does is it makes it so that you don't have to wait the 20 days. But if you maintain a non-responsive and you can show, look, I applied on February 1 and I served my notice on February 1, right? It's been 20 days and I can show on February 20th or the 21st that the application still shows non-responsive. You can then move forward with the eviction. You do not have to wait for a denial. That was the purpose of having those two options, because sometimes there won't be a denial. It'll just show tenant non-responsive. So at some point they have to provide you with a way of moving forward with the eviction. So any other questions? We got to the last one. You can either put it in the chat or you can unmute yourself and just ask.
If we have one more from Maurice, he asks, what if you have a tenant that signed a rental agreement where the landlord was left blank and their names, I'm assuming the tenants, and the agreement was not signed. The tenant names were misspelled. Who do you designate as the landlord? The owner, or are you on the lease as the manager of the property? And what names do you put on the 3-day notice? Those as they're spelled out on the rental agreement, and maybe use an AKA?
For the tenants, yes, that's a good idea. Just put all the names you know. For the landlord, whoever signed it, if it's a manager that signed it, then it's the entity that the manager works for.
Can I explain the situation, then my scenario there?
Sure.
Okay, so basically I inherited this property from a client. He gave me the lease of the rental agreement for the tenants. There was nobody, he must have written it up because there was no lease agent designated, no owner name on the lease agreement. The tenants' names were misspelled. He didn't sign the lease agreement. And so, and then not only that, but he gave the wrong address of the property. So initially when I started giving him the 3-day notices, I went to the tenant. When I gave him notice, he goes, "Hey, this is the wrong address. This is not 407C. This is 409 or something like that." So I'm like, "Oh, great. So now what do I do?" And so I started changing my notices around.
Okay.
So yeah, it's a complete mess. I mean, the names on the rental agreements were spelled improperly. I started to spell them right, and then I'm like, should I keep on doing AKA on every notice? I would think I would just keep doing AKA on every notice, because they didn't want to tell me their names, and they pretended like they didn't speak English, and when I spoke Spanish, I mean, it was a complete mess, So
in terms of the tenants' names, keeps doing the AKA. In terms of the landlord, if he gave these to you, did the landlord sign it?
No, he never signed it. Never, put his name on it. Never.
Fine.
Yeah.
Did the tenant sign it?
Yeah, he did.
Okay. The tenant signed it. Just have the landlord sign it, and then put his name as the landlord. It wouldn't make sense to put your name.
Yeah. Well, the problem is that they've been all through COVID. We've been given notices, and they've been non-cooperative. They say they can't spell their name. They can't. They claim they can't even speak English. And I speak fluent Spanish, so I try speaking to them, and they all also play dumb, and they're not. We try to get them. We send all kinds of letters, calling them, saying, "Hey, we'll help you participate in the program and
Okay.
the process." They refuse to do that. So yeah, the problem is that they never participated. Yeah.
Have the landlord sign the lease in his name if he's the one that owns it. If there's an LLC or a corporation or a general partnership that owns it, have that name as the landlord. Right, whoever owned it at the time that the tenant signed it. So
she just passed away, so now there's no owner. She just passed away like 2 days ago. So now we're left with.
Come on, Maurice, give me hard questions.
Yeah, it gets messier as the day goes along.
Yeah. Okay, next you can tell me all her kids live out of the country.
Yeah, I mean, this is a rental agreement that was created like I don't know, 10 years ago. So it's
right. So Maurice, this is definitely a situation where we're going to have to talk off camera, because now we are kind of getting into wills and trusts and probate issues, and we have to ask questions about what is her will and trust situation. Did she have one? If she didn't have one, who are her successors? Does she have any children, spouses, whatever it is? Does someone open a probate? We have to have a whole conversation about that stuff just in order to answer your questions about what to do the lease.
Yeah, and I mean, as far as I see this thing's heading towards,
eviction,
and not only an eviction, but I mean a lawsuit, because of course, the tenant's claiming, the landlord before they came to me was somewhat of a slumlord, and I've been going in there, and every time they have a repair issue, I've been trying to fix it, but he's going to claim that the day one when we go to the eviction.
So we have to be prepared for that, but not deterred by it. So Maurice, why don't you you can direct message me on the chat, or you can direct message Leonard, because I think that's what you were doing. Just send over your information, email and phone number, and we'll give you a call afterwards and see if we can help you out.
Okay. Sounds good.
Okay, cool. Anybody else? Any questions? Thank you guys for coming on. Really enjoyed spending a little bit of time with you this afternoon. Again, if you have any questions, feel free to email me, text me on the mobile, or just call the mobile number. We're happy to help in all of your real estate, landlord, tenant, and construction needs. And hope you guys have a great rest of the day. Thanks so much.
Right, thanks.
Thank you, Niv.
No problem.